Then any other matters for people in the courtroom?
Since I don't recognize everyone in that sentence, anyone else have a matter of me, like the time? All right, I'm gonna step out and I'll talk to my last client and I'll be.
All right. Then your name, sir?
Richard Simpson.
Oh, Mr. Simpson, come on up. I'm just going to go around the room, folks, and try and get people out of here. Again, I appreciate your patience with our proceedings today. Mr. Simpson's here. And Mr. Fitzgerald, are you on the line with us? Mr. Fitzgerald? All right, Ms. Gouveia, I know you're here. Pardon me?
This is Mr. Fitzgerald.
Okay, got yourself unmuted now?
Yes.
Right, okay. So this is Mr. Simpson, and he's here today for arraignment on 2 charges. First is cause number XZ00143884. A charge of assault in the 4th degree domestic violence and another charge of assault in the 4th degree non-domestic violence. And then in cause number XZ00143886, no contact order violation. Again, this time set for arraignment. Do you waive reading of formal charges and are prepared to enter a plea, Mr. Fitzgerald?
Yes, Your Honor, we would waive the formal reading and enter a plea of not guilty to all 3 counts.
Okay. And then the other matter that I have before me today, and just to bring you up to speed, Mr. Fitzgerald, yesterday I saw Mr. Simpson, and there was a motion from the state to amend the face of the ticket in the assault case to make one of the charges a non-DV charge. And without you being present, I went ahead and made that amendment because Mr. Simpson had made it clear at his first appearance in this court that there was not a relationship there that would qualify that as a domestic violence situation. And so we went ahead and amended that. So let me address that first. Do you have any objection to that amendment?
No.
All right. And then the other amendment or the other issue that's before the court today is a motion to modify the no contact order in the situation. And let me share my understanding because obviously ultimately I make any decisions on this matter. So I think it's important that I state what I understand of the circumstances. And then if I'm wrong, the parties can correct me. And so my understanding, Mr. Simpson, is you operate a hotel and you do a lot of the work hands-on at that hotel, stripping the beds, cleaning, cooking, shopping, and so forth. At this point, or prior to the incidences of this weekend, you were residing in a basement apartment in the hotel with your spouse, Ms. Tracy Simpson. So when we first dealt with the matter on Monday, it was my understanding that we might be able to allow Mr. Simpson to reside in an upper floor room at the hotel, and that Mrs. Simpson would reside in the basement, and they would keep a distance of 25 feet, or Mr. Simpson would always make sure he was 25 feet away from Mrs. Simpson. And that was the way the order was written. It was not clear enough with regard to that instance that he could reside there, and then an officer chose to enforce it because of the language that just simply said 25 feet away. And now Ms. Gouveia has presented a motion, an affidavit to modify the no contact order to say that 25 feet is insufficient, and that the no contact order should simply state that he's 25 feet away from, or some distance away from the Lyle Hotel and may not reside at the Lyle Hotel. And the only other factor to understand in this situation is that yesterday I authorized a civil standby for Mr. Simpson to get his essential personal belongings at the residence. And were you able to do that?
Yes, sir.
All right. So that's where we are today. Ms. Govea, I'll give you the floor now.
Hi, Florida. So per the information in our motion, and as I mentioned to the court yesterday, I haven't Mr. Fitzgerald was in this conversation, so I'll lay the record again. Prior to the first appearance in this matter, the state has been unable to reach Mrs. Simpson, Tree Simpson, the protected party at issue with the no contact order that we're seeking to modify. There are 2 no contact orders in this case. We're not seeking to do anything with the one protecting Spira, just the one protecting Tree Simpson. When we contacted her after the defendant's first appearance on July 13, 2020, when he explained to the court his significant work at the Lyle Hotel and the prior way that he and his wife had worked out getting space from one another in the past when they've had arguments. We passed that information along to Mrs. Simpson, and she felt that 25-foot distance proved insufficient to protect her. She could notify our office and there's no tree address, no contact order. At the time that I spoke to her, she was highly emotional and upset, and so that she would keep that in mind. The no contact order is written to prohibit the defendant from coming within 25 feet of a protected person's school, residence, or workplace. It did not specify, as the court pointed out, that he was allowed to be allowed to return to the Lyle Hotel and reside in the top floor. That was the issue, and that was that issue in the no contact order violation case. However, when he returned to the Lyle Hotel after being released to custody on July 15, 2020, the protected party determined that 25 feet was insufficient distance to ensure continued safety and peace of mind. I had a discussion with Deputy Jason Rytalk on that day after the arrest of Mr. Simpson for the alleged violation of the no contact order, and he explained that the Lyle Hotel's small size renders 25 feet impractical and insufficient. As he put it, essentially the only way for them to be 25 feet apart at any given moment is one person's on the back porch and the other person is out front. When I spoke to Mrs. Simpson, she also conveyed that she didn't feel protected or at ease with the 25-foot distance, and that it wasn't practical for her, and that she didn't want to be in a position where she was essentially, relying on him to leave a room if she entered it. The protected party and other employees of the Lyle Hotel are both willing and capable of managing the Lyle Hotel. The protected party is a 50% owner in the Lyle Hotel, and based on conversation with her, she believes that no reason exists for the defendant to continue to reside at or enter the Lyle Hotel. He can apparently manage his business as necessary remotely, and then, like I mentioned, she and other employees are capable of managing it as well, including cooking. She has no objection to the defendant contacting Natalie St. John, who's an employee of the Lyle Hotel, in writing for work-specific purposes and allowing Ms. St. John to convey messages to her as necessary. Ms. St. John, who I was put in touch with, has no objection to being the point of contact for the parties for management concerns, including passing along plans for upcoming events at the hotel, venues, and shopping and vendor lists. Lastly, Your Honor, we were asking for civil standby, but that's already done. We believe that as 25 feet are proven impractical given the layout of the Royal Hotel, and the victim has stated that while she initially thought that 25 feet would be sufficient, when she observed the defendant approaching the hotel, she realized it wasn't going to work or provide her with any sort of peace of mind or personal security, and that she didn't want to, again, rely on his goodwill that he would stay away from her 25 feet. She'd asked that it would be expanded, and so would the state, to make it more of a practical and effective order, Your Honor. We feel that good cause exists for modification, and certainly for clarification and specificity in the existing domestic violence no contact order is needed as well.
All right, Mr. Fitzgerald, have you had an opportunity to apprise yourself of the background on this case. It's come very quickly, but I had originally set arraignment for next week, but I moved it up to today so that we could work on this issue if necessary. So is there anything that you can add to this matter?
Well, Your Honor, I'd like to step back a little bit here. We entered a plea of not guilty to the cause number ending in 86, but after listening to Your Honor recall what was on the record as to that no contact order, I don't believe that if the court takes judicial notice of what I understood was said, that my client could reside in the basement or vice versa upstairs and the wife would reside in the basement. I don't think there's probable cause to support a violation that's at the base of the cause number ending 386. It seems as though my client was relying on what was said in court, and I'd ask the court to readdress a finding of probable cause on that ticket.
All right. I'm at this point today, I'm not going to readdress that. I'm not going to foreclose you from making a motion for dismissal or other motion that you feel is appropriate, but I'm not, my decision on probable cause stands.
And as to the modification of the no contact order, but Mr. Simpson may not understand, and perhaps, and correct me if I'm wrong, the court doesn't have jurisdiction over his wife, and so the court can't order her to leave the restaurant and hotel to allow Mr. Simpson to work there without any interference from her. That said, if there was any possible way that he was allowed into, to get in access to the hotel to prepare some sauces, it would only take probably an afternoon or one day a week, and also to allow him to check the inventory of staples and refresh, the kitchen. That would be ideal. But if his wife is not willing to participate in that situation, then but I understand that the no contact order prohibiting him from the entire building is probably the simplest and the most straightforward approach.
Ms. Govea?
No, again, based on conversation with Mrs. Simpson, she's conveyed that there are other people who are quite capable of cooking, including herself and at least 3 other individuals. They are even willing to rework the menu as needed.
Okay, so let me stop you there. The situation is with regards to Mr. Simpson, that this is his business that he owns. And so I see Mr. Simpson, even with the mask on, I can tell that the perspective on that is that means an employee is doing work that he could do, which is causing him to incur additional expense that he might otherwise avoid by doing the work himself. So I appreciate the information that you have with regard to Tracy Simpson's perspective on this. I'm not asking that you do anything else with regard to that, but this is a different wrinkle than finding a way to move through the process. This gets to the economic viability of the business in a situation where the hospitality industry is on life support. So with regard to that, if there's a mechanism where he could come to the building to do some work while she was out of the building, I would like you to at least work on seeing if that could work with Ms. Simpson and see if we can have a way that he can be there while she's not there on a schedule that could be established so that he could do some of the work in his business without causing her any diminishment in her security and privacy. It was my understanding at the first instance that she has another job outside of the Lyle Hotel here in White Salmon. So it may be able to coincide. It may be able to coincide with, that's fine. I did that to you and I appreciate that. I'll give you an opportunity when I'm done here. It may be that there's a way, if that's not the case, or if there's another case, to at least have a situation where he could get into the building when she was reliably not there and we would avoid any conflict.
Yes, Your Honor. My point that I was trying to make with my discussion again about Mrs. Simpson's perspective there is that the state would object. We believe there's no reason they would need to re-enter the hotel. In terms of management, she's also a 50% owner of the hotel. She explained that her boutique that she works at was designed to get her out of the hotel because Mr. Simpson likes to try to handle the whole thing himself, but she's more than capable of doing so, and she doesn't feel the need to continue with the boutique if she's managing the hotel, which she's willing to take the full time to do. But in regards to setting up the schedule, Your Honor, I'd ask the modification that we requested regarding written communication for management purposes through Natalie St. John, that at least be permitted. That would help them if they weren't able to come up with some sort of workable schedule and Mrs. Simpson agreed to it. If that's what the court decides, that modification would need to be in place.
Right. So here's.
St. John conveyed that it would need to be in writing. She doesn't feel comfortable with verbal communication. She's like it all in writing. So there's, in writing.
And when you mean in writing, what are you suggesting?
Email. She has an email address that would be available for. She wants the communication that she's going to be the intermediary on to be via email, is what you're saying. Yes, Your Honor. She'd prefer that, just so she can make sure that there's no confusion about what messages are getting conveyed on.
All right. Mr. Simpson, you have an attorney representing you. I don't want you to do anything that would diminish your ability to defend yourself in this matter. Mr. Simpson has indicated that he'd like to speak, Mr. Fitzgerald, and so I'm inclined to allow him to do so given the intricacy of this matter, but I respect your ability to represent him, and so is it acceptable for him to speak?
Right, I trust Mr. Simpson will stick to the talking points here and just discuss his role in keeping the restaurant and hotel viable.
Okay, so you'd like him to speak to that?
That's fine.
Okay, Mr. Simpson.
Just 2 points. First one is, I'm the 100% owner of the business. I bought it. I'm the one on title. We weren't married when I purchased it in 2014.
Right.
And then the second, she claiming that she's 50% owner, but I'm 100% owner of the business. And property and dirt. And also, the menu is quite complicated. I invented the menu, and it's a French influence menu. I'm a French chef, and it's quite complicated. And Natalie St. John, I'm sure, if they change the menu and turn it into something very simple, that makes perfect sense if she's going to take over. But the way it is now, I invented it. Those sauces are my invention.
Right.
So without me present for every one of those, I can't see that menu moving forward, which has kept us in business for 6 years.
Okay. All right, Ms. Gouveia, here's my position. I'm not going to get whipsawed in this courtroom into settling a divorce action or impending divorce action or property settlement between two business partners in the context of a protection order. I am going to grant your motion today to amend the order to allow the contact between Ms. St. John and to prohibit Mr. Simpson from coming to the property. But again, that's what I'm sensing in the background, that this is morphing into a dispute between these parties about ownership of an entity, and that's not proper as a protection order situation. With regard to that, then I would ask that you confer with with Ms. Simpson, who's not your client, but the alleged victim in this matter, and then see if there's a mechanism that will allow Mr. Simpson to be in the building at certain periods of time when she is out of the building in order to allow him to continue the operation in the way it was being operated this time last week. And if that's not possible, then I understand that, but I'd like you to at least inquire on that. And I know Mr. Fitzgerald will be following up on behalf of his client as well. So today my decision will be to allow the amendment as presented, but I'd like to see additional work done on this to see if there's a mechanism that can allow Mr. Simpson to be allowed back into the building at certain periods of time to continue the operation of the business as it was being operated this time last week.
Yes, Your Honor.
And it-
Regarding the amendments that I was requesting, are you changing the distance or like what'll be the wording on the?
Well, I am familiar with the Lyle Hotel, and 25 feet from the business or residence is reasonable because the Lyle Hotel is literally on the sidewalk. And so if he can be 25 feet from that and on a public street, he could be walking across the street and still be in the environs of Lyle. The Lyle Hotel, again, is right on the sidewalk. So I think 25 feet from the Lyle Hotel at all times until further notice or forever, I guess, under the terms of this order, will be the order of the court. You've gotten your essential personal belongings. I'll allow you to be in contact with Ms. St. John as necessary to do that. And then I'd like to see more information developed with regard to the operation. And I'm not going to be engaged in a situation where we're divvying up this restaurant based on community property values and other issues in the context of a protection order situation. I guess it goes without saying, but I'm going to say it, that this is a different situation because we're talking about not just the residents, but a place of business. And those are one and the same in this situation. And so that creates challenges with regard to protection orders. And so my position today, again, will be to grant the motion from the state, and if there's further proceedings need to be done with regard to that order, then those can be presented to the court. Then with regard to the next date on this matter, Mr. Fitzgerald, I'd like to have another hearing on this matter on August 5th. But just as I,
will probably be
yeah, I
on the
just,
road at that time, but I can appear by telephone.
okay. I don't want to, the other thing I could do is have the hearing on the, have it on the 29th. Would that be preferable to you, Mr. Fitzgerald? Then you're not having to juggle this on the road.
Right, that would be better for me.
Okay. Ms. Gouvet, any objection to that?
No, Your Honor.
All right, next hearing will be July 29th, 9 a.m. Again, you can appear in person as you've done today or by telephone. Just be in touch with Mr. Fitzgerald about that issue. If there's any need to have the matter brought before then, that we have a docket next week as well. So, but in any event, 29th at 9 a.m. Thank you. All right, that's it. Thank you.
Your Honor.
Thank you. And sir, what's your name?
Casey Lynch?
Casey Lynch. This is Mr. Levitt's matter. Could I come back to that, because that's a plea and that would take a little bit of time. So I want to try and clear the courtroom if I can. Next, what's your name?
My name is James Bartz. I'm here for my son, Adam Bartz.
Okay. Mr. Fitzgerald, this is your matter, and it appears that there's a request here to modify the no contact order between Mr. Bartz and his son.
My son, yes, sir.
Mr. Bartz, are you on the line with us?
Yes, sir.
Okay. And then, Mr. Fitzgerald, you're still with us?
Yes, I am.
Okay. Ms. Cook, you're on the line. Anything you'd like to add to this request?
Your Honor, we met with Mr. Bartz, the alleged victim in this case, and we did not find any concerns.
All right, Ms. Gouveia? Wait, yes, it's your case. Ms. Gouveia?
Yes, Your Honor. It's the same case.
Right. And you didn't.
Your Honor, that Although Mr. Bartz does have a considerable history of assaultive behavior, which does present some worries for the state, I have been in contact with the protected party, David Bartz. In this particular instance,
Okay, Mr. Adam Bartz, we've been on the phone before. You know better than that. You don't need to offer that clarification. We know who he is.
Yeah,
Yeah, that's okay.
apologize for that.
I know.
I'm on speakerphone.
I-
That was my bad.
Yeah, it was. Yeah, it was. Yeah, it was.
Yeah.
my apologies, Your Honor. James Bartz, thank you for the correction.
I'm sorry.
I've been on the phone with the protected party, Mr. Bartz, regarding this matter, and I did discuss the no contact order with him. This was back in May. Based on probation commentary that they don't see any issue, and on my conversation with the protected Mr. Bartz, while I do have some concerns, I understand that he wants to try to see that to help the defendant get assistance with matters that might be possibly underlying the election itself in this case, and other matters currently going on in district court, Your Honor. I would leave it up to the court's decision whether or not to lift the no contact order. I have no position one way or another, but I'm certainly not objecting.
All right. Mr. Bartz, let me, again, as I did earlier, explain or state my understanding of the background in the situation. Adam Bartz is on a journey here to obtain sobriety and live a productive life and be a contributing member of our community. Correct, Mr. Bartz?
That is correct.
And that journey is not a linear path that goes from bad to good. It has some bumps along the way, and we're experiencing some of those bumps. But in any event, that's where we're going with this. Now, my view, being familiar with Adam Bartz, is Adam Bartz probably should not be engaged in behavior that involves the consumption of alcohol, non-prescribed drug, or marijuana. So in connection with that and the alleged background in this situation, that may have been a misstep that creates some of the problems that we have here today. Although Mr. Adam Bartz is a person with free will and could have stepped away from that and made the right decision, he may not have in this situation. Mr. Bartz, you're not the kind of person, Mr. Adam Bartz, you're not the kind of person who can have a couple of beers. That's not the way that you are able to run your life effectively going forward. Now, I understand you'll get an opportunity, Mr. Bartz. Mr. James Bartz. Mr. James.
You're breaking up. I'm getting bits and pieces.
That's okay. Mr. James Bartz.
Okay.
Your request states that you don't have any fear of your son or that he's any threat to you. Is that accurate?
Yes, Your Honor.
Okay. And you'd like me to grant the motion to extinguish this no contact order?
Yes, sir.
Okay.
May I say a few words?
You may, please go ahead.
I would ask the court to extinguish the whole case. My son is going through a divorce right now. That's not the person he was that day. That's not who he is. And I know that I can help him if I can be around him. And I know that going through divorce can do a lot to a guy's mind and make him do things they normally wouldn't do.
Right.
So I would ask the court to please extinguish the no contact order. And I would ask the court to drop all charges.
Okay. With regard to, were you able to hear that, Mr. Bartz?
Bits and pieces, yes.
Okay. What your dad has stated is that you're going through a divorce. I'm aware of that situation, and that you are dealing with difficulties that he thinks he can help you out with. And he'd like to be able to have contact with you to do that. And that the person that that you're a better person than is reflected by some of the police reports and other things that I've reviewed in this situation. I believe in my heart that you are capable of being that person, and I think sometimes you're not capable of being that person. You need to find a way to make sure that you are the better person more often than not, and I hope you're able to do that. With regard to the no contact order in this situation, based on the request and the information I've been provided, I'm going to extinguish that order. And so what I'll do is sign an order to that effect, and then that'll be entered into the system that law enforcement has. Do you have any intention of seeing Adam Bartz in the next 24 hours?
Not until it's official that he will.
Do I have any intentions of seeing
Well,
my
it's-
father, or are you asking my dad that question?
I'm sorry. I am asking your dad that question. He wants to make sure it's official.
Okay, sorry about that.
So what we're going to do is make a copy of the document and then give that document to you. And then if you see him in the next 48 hours, have that document on your person.
Yes.
Yeah. Well, is he the? Okay, yeah, we're going to have you sign the document if you don't mind. Yeah, right there. And then again, we'll give you a copy of the document. You keep the document on your person when you're around your son. So if there's any question, you can show that to law enforcement and say, it's okay for me to be around
Yes, sir.
Adam.
And your name is James Bartz?
Yes, sir.
All right. Any question from you, Mr. Fitzgerald, with regard to this?
No, Your Honor, I would just ask that this be set on for the 29th.
Okay, thank you for reminding me of that. Adam Bartz, it's going to be, your next court date is going to be the 29th.
Roger that. 9 a.m.? 10
Yes.
o'clock?
9 a.m. Always 9 a.m.
Roger that.
Okay.
Thank you, Your Honor.
All right, so, and Ms. Gouvet, anything else from you on this matter?
No.
Okay, all right, orders extinguished. Again, keep that on your person. I'm not gonna, I appreciate your position with regard to the case. I'm not gonna grant a motion to dismiss it today, but you can be in contact with your son's attorney about those issues if you'd like.
Okay, thank you, Your Honor.
You bet.
My release?
You are. Yeah, thank you. Ma'am, what's your name? All right. Ms. Calkins is here. Come on up. Have a spot on the X. Time set for arraignment in this matter. Charges theft in the third degree. Waive reading of the charges and enter a plea, Mr. Fitzgerald.
Yes, Your Honor.
Okay. I'll enter a plea of not guilty on Ms. Calkins' behalf. And then if it's acceptable to the parties, I can set this matter for the 29th as well.
That should be fine. And if the court, off the record, if she could write down her best phone number, I will contact the court later and get that.
She could give you a random number, but she doesn't have a phone that works right now. Do you have a message line, someone you know that has a phone? Okay, and you just,
Well, I have a number that she left me yesterday or the day before, and if that's the same number, then I will call her at that number.
There's some of the time, but not that often, so.
so here's how this works. Let me just kind of flip the script on you a little bit. If you're waiting around for your lawyer to call you for this to go forward, that may not be a good strategy given that you don't have a phone reliably that could answer. So you need to get to a phone and contact Mr. Fitzgerald to stay in touch with him so that he can help you with this case. Make sense? So when you're near a phone, call your lawyer. All right. But then he has a number and you say it may or may not work. If there's a better number, this would be an opportunity to give it to him while he's on the phone here. Does not have a better number to give you, but it assures me that she will be in contact with you and initiate that contact as much as she possibly can. All right.
Right. Well, she has tried several times, so I understand that we'll be in touch soon.
Okay, keep that up. It's not easy to do, but I want you to keep trying to be in touch with Mr. Fitzgerald. We'll be back here on the 29th at 9 a.m. Again, you can appear by phone if you're able to, but otherwise you're welcome to be in the courtroom. All right. Thank you, Ms. Calkins. Mr. Franklin.
Yes, Your Honor, this is Courtney Cook with probation. This was noted up by our office.
Okay. And what would you like to discuss with regard to this matter?
Your Honor, the court ordered him to do anger management. The defendant has significant developmental disabilities. There has to be some cognitive ability to do and participate in anger management. Is the request of the agency that the defendant not engage in the anger management at this point in time, and that maybe other resources would be available. In speaking with both Mr. Larry Barker as well as Melanie Osborne of the Juvenile Department, they've had years of experience with the defendant. I don't know that we have the resources available to provide for the defendant.
Okay.
So we would ask that he be moved to bench probation. I'm not sure that the city is in agreement with that or not at this time.
All right. I'm not reappointing you on this matter, but if you want to stand up. This is Mr. Fitzsimon's matter originally. Mr. Rainier, what's the city's position with regard to that?
We don't object to that, Your Honor.
Okay.
We wouldn't object to that either.
Win for Mr. Fitzsimons. Mr. Franklin, do you understand what we're talking about here? Let me just restate it so I'm clear, and I don't want to take any more time than necessary in this situation. What they're telling me is that they don't think that you would be a good candidate for the anger management class at this time. That doesn't mean that.
Yeah, I know that is because of the.
Okay. In any event, I'm going to move this matter to bench probation, and then the requirement for anger management will be extinguished. And so, Ms. Cook, would you prepare an order to that effect and then submit it to the court off the record?
Yes, Your Honor.
Okay, then that will take care of things. Thank you, Mr. Franklin. I appreciate you being here today. Thank you, sir. And your name? A little bit louder. Okay. Mr. Okay, is Mr. Kraskoff's going to be lengthy as well?
No, not necessarily.
Sir, what's your name?
Levens.
Jason Levens. Yeah. I'll take Mr. Levens' matter first then. All right, Mr. Levens is here, Mr. Rainier, and he is appearing without an attorney.
Correct, Your Honor. Mr. Levin was sent a statement of defense on plea of guilty form from my office via email last week with instructions. I'm hoping that he has that document and has signed off on it.
I just need to sign.
Okay, the pen there. So Mr. Levens is got the document, and he is signing it right now.
Great. This document, Your Honor, proposes that he plead guilty to malicious mischief in the third degree, domestic violence. The city's recommendation is for a fine, $250, conviction fee of $43. Specifically, $1,000 fine with $750 suspended, 90 days jail, sentence suspended, bench probation 24 months.
All right. Did you understand that, Mr. Levins?
Yes.
Why don't you pass me that document? Thank you. So when you plead guilty to these charges, you give up certain valuable rights, the right to a trial, the right to hear and question witnesses, the right to appeal a finding of guilt and so forth. When you do that, most importantly, to proceed today, you're proceeding without an attorney. You're agreeing that a finding of guilt can be entered and that you will be convicted of a crime. So going forward in your life, that would be something where you would have to say on all job applications that you have been convicted of a crime. Prepared to proceed in that fashion? You understand that you're giving up that valuable right to have an attorney. Are you willing to give up that right today? Has anyone made any promises or threats to you in order to give up that right? Okay. The document states that on May 8th, 2020 in White Salmon, I caused physical damage to property jointly owned by another person. Is that your statement? Do you adopt that statement for, okay. So with regard to the charge then of malicious mischief in the third degree domestic violence, what is your plea to that charge?
Guilty.
I'll make a finding that plea is being made knowingly, intelligently, voluntarily, that there's a factual basis for the plea, and the defendant is guilty as charged. Mr. Rainier, do you know off the top of your head whether this plea of guilty would result in a firearms restriction for Mr. Levins?
I'm already restricted, I'm a felon.
Okay. But again, I have to go through it in this situation. Mr. Rainier?
No, it would not further complicate his life.
Okay. All right. And you may not have heard, he already indicated that he's under that firearms restriction based on prior cases.
Yeah, I'm aware of its history, Your Honor. None of it's super recent. This proposal was based in part upon, I believe, his expectation, since he said this to the police, that he felt he was allowed to break objects which were his. Unfortunately, they were both his and another person's, Ms. Curtis. Those included a TV remote and looks like a shower curtain. So from our standpoint, he stepped right up to the plate, said he would get this taken care of. We're not seeking anything further than what I recommended.
Okay. And then, Mr. Levins, before I impose any sentence on you, you have an opportunity to say anything that you want to say to the court. This is your opportunity to do that. Is there anything you want to say to me?
No, I'm familiar with the court. I used to get in trouble a long time ago, and I spent a lot of time in jail, and this is just a fluke thing, and I'm not drinking or anything. I'm just being good. I'm just going to work. We're having a baby girl in November.
Okay.
We're doing real good.
All right. Congratulations on that. And also, even though you spent some time in jail and then undoubtedly around a lot of people who are smart about criminal law, you see now that maybe you need to bone up on it before you employ it in your daily routine. Right. Okay. That makes sense. I think we talked about that at your first appearance as well, that maybe you had a misapprehension about the laws with regard to property and other things. Right. So better just to walk out of the room rather than destroy things on your way out of the room.
Exactly.
Yeah. Okay. All right. Then I'll adopt the recommendation here that's been set forth, which is $1,000 fine with $750 suspended, leaving $250 to pay, $43 conviction fee, and 90 days in jail with 90 suspended, and bench probation for 24 months. So the total is going to be $293. Is that something you can pay today?
I can pay $150 right now, and I can pay the rest of the morning.
In the morning?
Yeah, I can pay it tomorrow.
Yeah, why don't we do this? Just pay it all tomorrow. You can drop the payment off in the box on the side of the building and just make that payment there.
Yeah, I get off at 3:30 tomorrow, so I'll just throw it in there.
Perfect. All right.
Cool.
We'll expect it to be paid.
I got cash for right now.
That's fine. It'd just be better just if you just put it in the box, and we'll give you that extra day to do that.
Okay.
All right. So it's $293, and that'll be paid by the close of business tomorrow, the 16th. Anything else, Mr. Rainier?
There you are.
All right. Thank you, Mr. Levins. If you want to get a copy of that, you can wait and she'll make a copy and give it back to you. But what I did is I filled out the face of the ticket with the information that I just passed sentence on. So there's no judgment in this case. It's just, so if you want that, we can give that to you.
No, I'm good.
Okay. And anytime you want it, you can just ask for it to be mailed to you if you need it for something else.
Okay.
All right.
Thanks, man.
Thank you. All right. And then who's outside? The woman outside?
She was actually here for Mr. Kraskoff.
Okay, it's someone with Mr. Kraskoff. All right, Mr. Kraskoff, let's call your case. All right, Mr. Rainier, this is Mr. Kraskoff's matter. And Mr. Kraskoff is present in court. And Mr. Levitz.
You're all right. Is this on for Raymond?
No, arraignment was held on the 10th of June. This is just a follow-up hearing after that.
Okay, first off, I have only, unfortunately, my client is, homeless and is living in an area where his phone, he's not reachable. So today's the first time I really had a chance to talk to him. The city has given us an offer. At this time, my client is not willing to accept that offer. I need to talk to him more about the case.
Okay.
And also then get back to Mr. Rainier, so.
Do you want to, we can set it for the 12th of August and allow you to do that, or we can put it for the 29th of July, either one.
12th of August, should have, we'll have notice of the court then.
Okay, and then
How
we'll
the court, how the case will
proceed then. Okay, so we'll set the matter then for August 12th. Mr. Rainier, anything from you on this matter?
Not on this matter, but if there are matters that are set August 12th is clearer for me than the 29th.
Okay.
Thank you.
That's good to know. All right. So I think we've only set Mr. Fitzgerald's state matters to that date, but I see that Mr. Fitzgerald has some other matters and he's going to be out of the area for the month of August. So we're going to try and accommodate that schedule as best we can, although he has offered to appear by telephone. Anyway, with regard to Mr. Kraskoff's matter, back to that, we're back here on August 12th, 9 a.m. As best you can, be in touch with Mr. Levitz about how we're conducting court on that date, whether we can, if possible, if you want to appear by phone, we can allow that perhaps. If not, then in person, as we've done today.
I'm not sure if the alleged victim in this case is in court. I don't know, I'm sure if she actually filed a petition for I believe that the no contact order is in question here. Apparently she did not file a petition.
All right, so if there's a process that we utilize in this court, if you'd like to have a modification of that no contact order, and that would involve being in contact with, starting with adult probation and then programs for peaceful living, and then you can present that to the court after you've done that. Pardon me? Okay, so I have Ms. Cook on the line with me right now. Do we have Ms. Cook's card there?
Yes.
So we have a card for Ms. Cook. That's your first call. Then she can explain the process to you. You're Ms. LaFleur, is that right? So Ms. Cook, in court today is Paula LaFleur, and she'd like to discuss the no contact order with you. We're going to be giving her a card so that she can contact you, and so I'd expect you to get a call from Ms. LaFleur.
Thank you, Your Honor.
Okay, so come on up here. We'll give you the card, and then you can initiate that proceedings with Ms. Cook, and then she'll show you how to go from there. And then the next matter is Mr. Lynch. Casey Lynch. Come on up, Mr. Lynch. So, Mr. Lynch, I've been handed a statement of defendant on plea of guilty. This is a document whereby you give up certain valuable rights and agree to plead guilty to the charges in this matter. Are you prepared to proceed forward today? Do you understand the document? You understand what you're doing?
Yeah.
A little louder.
Yes, sir.
Okay, it's good.
Sorry, I got a call from it. It's bigger.
That's all right. We'll keep our masks on. We'll suffer through this together. Then you understand when you plead guilty that there's an agreement here. I'm not obligated to follow this agreement. I can impose whatever sentence I feel is appropriate within the mandatory guidelines. You understand that? Okay. Also understand if you're not a U.S. citizen, there may be adverse immigration or naturalization consequences from a plea of guilty. Okay. Then the document states at paragraph 11, on March 14th, 2020, in the city of White Salmon, I got into an argument with Billy Lynch that turned into a tumultuous fight. Do you adopt that statement for purposes of this proceeding? Okay. Mr. Rainier, is there anything to supplement that with? Anything else I should know?
There seemed to be some disparity in allegations of who started this, but this seems to be the way these two brothers communicate physically, and as long as they keep doing that, someone will keep getting charged.
All right.
Robert, just for the record, I believe we need to amend charge sheets to be amended.
Right. So the original charge in this matter was assault in the 4th degree. And so the amended charge we're proceeding on today is disorderly conduct.
I wasn't sure.
Is that disorderly conduct domestic violence, Mr. Rainier?
No,
Okay, just disorderly conduct.
It's also, I believe it's a white salmon ordinance. I don't know if that's what the charge under. That's what I put on the statement. I don't know if it took it out okay.
It does show that. Mr. Rainier, are you comfortable with this being charged or amended to the white salmon ordinance?
no, I anticipate it would be the underlying RCW. I don't have it in front of me. I can find it in 1 second. Here's out.
They have a specific disorderly conduct charge.
Right, and so this would be under the statute. And Mr. Rainier, we're broadcasting today on Zoom, and I'm unable to open my computer because it's been taken over by the.
Yes, it is 9A.84.3030.
Okay. All right. So then, with regard to the amended charge of disorderly conduct being a violation of RCW 9A.84.030, what is your plea to that charge, Mr. Lynch? Okay. I'll make a finding that that plea of guilty is being made knowingly, intelligently, voluntarily, that the defendant understands the charges, the consequences of the plea, that there's a factual basis for the plea, and the defendant is guilty as charged.
Does the court want that signed or on record suspicion? Because I did not sign it.
Right, I'm going to pass it down when we're done, and then I'll have you and your client sign off on this version, then I'll append the version with Mr. Rainier's signature to that. So we already have that in our court file. So then the recommendation, Mr. Rainier, is 90 days in jail, credit for 1 day served, 89 suspended, $250 fine, which is $1,000 with $750 suspended, $100 investigative fee, $50 jail costs, and $300 court-appointed attorney's fees. Anything else?
No, Your Honor.
All right, Mr. Levitz, anything else?
No, Your Honor, I follow, that's the final amount of my attorney's fees. That's all I'm going to be submitting.
All right. And Mr. Lynch, this is an opportunity for you to say anything that you want to say before I impose sentence. Is there something you'd like to say?
We have a statement from his employer. I don't know if the court wants me to read it or.
Yeah, I'd prefer you read it rather than, or someone read it to me.
Says to whoever it may concern, Casey has been working for me as a part-time on-call employee. He has been a great asset to the team by his flexibility. I will continue to work with him as we move into each season. This is a statement from my boss. She has it up for her.
All right, and who is your boss?
Her name is Mona Degali.
And where does she work?
We clean houses.
Okay, all right.
The name of the company?
Cleans and Things, LLC.
Okay, anything else that you want to say, Mr. Lynch?
I don't know if you want her phone number or.
No, I don't, but anything you want to say?
I just want to get it over with and disorderly conduct. I agree with the lawyer on this one, so.
Okay,
I can just fill in. I think it's appropriate in this case because he was living with his brother. You know, they've had on and off. From what I can understand, the brother's been under a lot of stress himself. He's got a son that's been in trouble in juvenile court. And things just got out of hand. My client didn't start. The reason why it came across the way it did is because his mother lives with the brother, and the mother really didn't see how it started, but she did say that she saw it, but she didn't, according to the client anyway. But he's been very, very good about keeping in touch, and this has been going on for a long time. I think it's the appropriate result. I agree with Mr. Rainier that if these guys can't get along, they shouldn't. They can't obviously live together at least, and he's living with his sister, and things are going well. He's working hard, saving his money, and hopefully he doesn't really have. I don't think he's got much of a criminal history either. So I'd ask for a recommendation.
all right, Mr. Lynch, I can see here you're 48 years old. It's time to stop fighting.
I know.
Yeah.
I was thought for that a long time ago.
Yeah, right. But now it really is. You don't want to be a 50-year-old person in district court dealing with misdemeanor charges. All right. Okay. So figure it out. You'll have to do that. I can't tell you how to do that, but I would stay away from those things that cause you to be brought into court. If that's substances, if that's broken logic, if that's poor relationships, get those things out of your life and stop coming to court.
I've been doing a lot better. I haven't been drinking or anything.
Great. Well, good.
Plus my sister, my sister's strict. She won't allow it.
Okay. Well, that's good. Pay attention to that. Congratulations for making that change. That's not easy to do, but it's not ever just done and over with. That's an everyday thing. So keep up that good work, and I hope I don't have to see you back here again.
I hope not.
Okay. It's going to be $700 is going to be the fine amount, legal financial obligations. And so what I'll allow you to do is make payments on that, $25 a month. So long as you continue making those payments to the court here, then everything will be fine. If you stop making the payments and I don't hear from you, then I'm going to assume you don't want to pay anymore, and I'll send it to a collection company. At that point, it starts to draw interest. It gets harder to get out from under. So if you're going to be late or light on a payment, contact me. I'll work with you. If I don't hear from you, I'll send it to a collection company. Okay. We'll make the first payment due. Can we do that August 1st?
Sure.
Okay, August 1st and the first of each month thereafter, $25 a month.
Well, the best way for me to get a ride would be like Monday, Tuesday, and Wednesday. Because I have a friend that's.
I can mail payments.
You can mail the payment in. You don't have to come in with the payment. Yeah.
Mail payments.
Yeah. Yeah. We're going to have you sign a card that says you'll make those payments. There's a ledger on that card that you can keep a running total of the payments that you've made and the declining balance of the amount that you owe. And address is on the top of that piece of paper, as well as our phone number. So just keep that with you, keep track of those payments. If you want to pay more in any month, you can pay more, but
I'll be paying more because
okay.
they're gonna bump my wage up to $15 instead of 12.
Great. All right. So we'll expect you to do your best with that, but we want you to make at least $25 a month the first of each month. All right. And so what I'm going to do is I'm going to hand this down to Mr. Levitz, and then right, if you could sign that, and then Mr. Lynch, you sign it, and Mr. Lynch, you bring it up here to the clerk, sign off on the time payment card, and that'll take care of things. All right.
All right, Casey. Sign here. And then you're gonna put the pen there and bring it up to the clerk. That's it. Thank you, Ron.
Thank you.
Thank you, Mr. Rainier.
That's it, just sign there.
That's it. Yeah, and hand it to the clerk, and then she'll have you sign the time payment obligation.
For future reference, if I want to send something like that to the court, I'm assuming I should try and send it as a PDF.
So was your
Yeah,
mail-
that would work.
If I send it as a
PO box,
Word,
did your
I
mail
wasn't
address
sure.
still PO box?
A PDF or Word, either is fine.
Is your mailing
Either will
address
work.
Still
Sometimes
2661
those,
PO box. Okay.
those forms don't print out. I think that's what happened.
Yeah,
Mr. Rainier was saying when we sent it, but not everybody has what is it, Adobe Write, where they can actually
right.
write on it, but everybody pretty much has Word.
Yeah, if you send it in Word, I think that'll work. Mr. Rainier, you're familiar with that program, are you not?
Yeah.
Okay. All right, that should work.
I think I had one more matter or one or two. If you want to get me out of here.
I want to get anyone out of here who's in here, and that's just two of you now, so.
Yeah, yes.
So Mr. Fitzsimons has a big roster here. Mr. Levitz, which ones do you have?
I have,
Total 7.
Felicity
Should
Nielsen.
start paying on that date to sign here.
and she should be on the phone. She's still there.
Oh, yeah. Ms. Nielsen, are you on the line?
Yes.
Okay, thank you. This is Ms. Nielsen's matter. It's a City of White Salmon case.
Your copy,
It's
please.
cause number
Phone
XZ
number's there.
0228984.
Thank you.
And this time set for arraignment in this matter.
Okay,
This is the
all right.
first chance I've had to, well, I think I just got the discovery
That's it. Mhm.
yesterday, I think it was, and I didn't have a chance to discuss with my client. I could, if the court, we could enter, reserve a right to enter not guilty plea at this time.
All right?
Set it over for a convenient date. In the meantime, I'll have a chance to talk to, my client. I believe I talked to the prosecutor.
Okay. Next date we'll set for this one, Mr. Rainier, is August 12th. Does that work for you?
Yes, thank you.
All right. August 12th, 2020 at 9 a.m. That's the next time we need you to be available, Ms. Nielsen.
Okay.
She has been in good contact with you, those things on the record, and.
Okay.
Felicity will be in touch.
All right. That's all we need from you, Ms. Nielsen. You can hang up now. Thank you.
Okay.
And then what else do you have, Mr.
I
Levin?
think that's all I have.
That's all I see. All right.
All right, we can set it. Thank you, Ron, you're awesome.
Thank you.
Do I need copies of anything?
No, you're fine. If you want,
How it is.
that's what you got. You're good.
All right.
Okay.
All right, thank you. And then let's now it's just you and me, Mr. Fitzsimons. So I think my temperature was 97.4 this morning, so you're safe.
All right.
Okay, so let's get some people off the phone. I see Ms. Hochter has some matters. Ms. Hochter, are you on the phone?
Yes, Your Honor, I am.
There you are. Okay, let me call it looks like you have two matters today. Which would you like to call first?
Well, I'm aware of one. We have Mr. Moser, and we're entering an SOC. I believe Summer gave that up to the bench.
Oh, there it is. Okay, Mr. Mosier, are you on the line?
I am.
Okay, you understand in this situation, stipulated order of continuance means that you're going to agree to do certain things. And if you do those certain things at the end of the time frame of 12 or 18 months, the matter will then be dismissed. If you don't do those things at the conclusion of that time frame, I will review the police reports in this matter that you stipulated to their admissibility of, make a determination of your guilt or innocence, and proceed right to sentencing. Do you understand that? Okay, you agree to, I see your signature on this document. You agree to abide by the conditions of this SOC?
I do.
Okay, that is, you are to have no criminal law violations, consume no alcohol, non-prescribed drugs or marijuana, pay $150 as court costs, an emergency response fee of $550 to West District Court, and within 12 months, supply completion of an anger management evaluation, and I assume any treatment that's required as a result of that, and marriage counseling completion, and that'll be provided to the court.
Yes, Your Honor.
All right, Mr. Rainier, is that your understanding as well?
It is. There's been a lot of hands-on with this case. I spoke originally with the victim and have spent a lot of time speaking with counsel associated with this. We think this is satisfactory for these folks. They seem to have already taken significant steps to move forward.
All right, Ms. Hochter, anything else?
No, Your Honor, we just have to enter it as provided.
All right, I've done that. Then if the parties would like copies of that document, just let the court know, call the court clerks, and they'll provide you with copies of that. And then, Ms. Hochter, the matter that you were not aware of that we have is Ashley Lumbert. And this is the time set for the completion of a stipulated order of continuance in a state matter. And that was entered on the 11th of July, 2018. It appears that Ms. Lumbert has paid her fines in this matter, and is the matter set to be dismissed? Ms. Govea?
Yes, Your Honor.
All right. So again, this is Ashley Lumbert, Lumbert, cause number 8Z0423286, and this matter is dismissed.
Thank you, Your Honor.
You're very welcome. All right, that's it, Ms. Hochter, for you, I think. Thank you.
Thank you very much.
All right. Mr. Fitzgerald. Marcus Delatorre.
Yes, Your Honor.
All right.
Yeah, I'm here.
Is that you, Mr. Delatorre?
Yes.
Okay, thank you for being on the phone with us. Mr. Levitz withdrew in this matter in June, and so this is our first hearing after that event. Mr. Fitzgerald, are you able to opine as to how this matter should proceed forward at this time?
Your Honor, I had some technical difficulties that I kind of had stalled working on this case. But anyway, long story short, I didn't think I had the discovery, but I did have the discovery. I just couldn't download it for some reason. I have that now. I'm just asking for additional time to do some investigation and research.
All right. How about if we allow you a couple weeks to do that, and we set this matter for the 29th?
That's fine.
All right. Ms. Govea, any objection to that?
No objection, continuance. This was a situation in which we did give them the discovery on the 24th of last month, but I understand how technical issues work, so, no objection.
All right, Mr. Delatorre, can you hear me?
Yes.
All right, we're going to need you back in court on this matter on the 29th of July at 9 a.m. And I anticipate we'll still be handling court on the telephone then, but please stay in touch with Mr. Fitzgerald so that you understand the requirements and make sure that you arrange your schedule to be present with us on that date and time.
Okay.
All right, thank you very much.
All right. Yep.
You can hang up now. Next is Mr. Kamara, Paul Alexander Kamara, or Kamara.
Yes, Ron.
And so the defendant was having phone trouble last time, but we held the arraignment on the 24th and set the matter over to today's date. Is Mr. Kamara on the telephone with us? Okay, hearing nothing, then, Mr. Rainier, what's the city's position on this matter?
Your Honor, if I could interject before, I did talk with Mr. Kamara this morning, and I gave him the number and the code to call in, so I'm not sure. I just fully anticipated that he'd be on the line.
All right.
Mr. Fitzgerald, is this the matter we exchanged emails on yesterday?
Correct.
Your Honor, the city is not requesting a warrant at this point. We'd like it set over to August 12th.
We're trying to avoid that for Mr. Fitzgerald's vacation.
Oh, yeah, I apologize. I knew he was going to be gone. We're fine with September. His FTA is noted today.
Okay.
September works.
All right. So our September date then would be September 16th, Mr. Fitzgerald.
That should be fine.
Okay. All right, then that'll be the next date on that matter. And then the other matter I have for you, Mr. Fitzgerald, is I thought there was one more. I guess not. Do you see that you have anything else in the docket, Mr. Fitzgerald?
I don't believe that I do.
Okay, I concur. All right, thank you for your time this morning.
All right. Take care.
All right, and now let's go to Caleb Cochran.
Yeah, this is task for review on an SOC. My understanding after speaking with the state is that Mr. Cochran has completed everything that's been requested of him under the SOC to this matter be dismissed with prejudice.
All right, Ms. Govea, Mr. Fitzsimons is asking that the matter be dismissed. Any objection?
No objection, Your Honor. Again, just to lay the record here, this is a situation in which Mr. Cochran was alleging that he'd done everything that he was required to do, but he failed to provide proof of it. So the continuance from last time was to allow him to provide proof that he'd completed his ADIS as ordered. He did so we have no objection.
All right, that matter is dismissed. Then I have, well, you tell me, it's, there's some probation violations. Which ones would these be of yours, Ms. Govea?
Sorry,
I'm sorry. I'm just trying to get you, I'm trying to clear your docket, Ms. Govea, so you can get on your way. What else do you have this morning?
the one matter that I think that there's another SOC review, Your Honor.
Is that Andrew Mills?
We've already done Cochran. Yes, Your Honor.
Judge. she
Yes,
has-
I'm
she
here.
has Beeks too.
This is good, Mr. Rainier.
Yeah.
This is Mr. Mills.
Mr. Mills, you're on the line with us. All right. This is a time set for completion of a stipulated order of continuance. And so, Ms. Govea, what's your understanding of the level of completion of these matters?
Your Honor, he certainly completed his legal financial obligations and he stayed out of trouble. I just have a question for him regarding whether or not he actually paid that back tax that was owed for his SOC and obtained valid title.
On that vehicle?
So,
Provision,
Your Honor, so give me just a moment.
I'll get it. Provision 4 says the defendant is to pay delinquent taxes and fees to obtain a valid title to be deposited and distributed in the same manner as if the taxes were properly paid in a timely fashion. Did you do that, Mr. Mills?
From my understanding, yes, that was done right after I had gone through this situation. I then drove that truck for a remaining few months and sold it to a friend after that.
Does that answer your question?
The state reviewed this as complete.
All right, then I'll dismiss this matter.
Okay.
Matter's dismissed. And then, Ms. Govea, anything else?
Let's look over the docket one more time, Your Honor, really quickly.
Am I good to go, sir?
You are. Thank you, Mr. Mills. You're done.
Thank you, Your Honor. Have a good day.
Your Honor, that concludes my matters. The only other state matter is a conflict that Mr. Rainier is handling.
All right.
I believe I'm done till this afternoon.
Okay, thank you so much.
Thank you.
All right. Mr. Rainier and Mr. Fitzsimons, I've got a number of matters. I've made Mr. Fitzsimons sit here in this German-infested facility for all this time. And so I'm going to allow, and he's wearing glasses, which have been fogged since about 9 o'clock. I'm going to allow him to call the cases in his order. It's my way of making up.
Run down the docket in order and start with Mr. Beeks.
All right, Mr. Beeks. Is Mr. Beeks on the phone? Oh, do we want to? We can call the jail and get him.
So, yeah, why don't we do that? That would make some sense. Mr. Beeks is prepared to, he needs to be arraigned on the new driver while suspended, and he's prepared to admit on the probation violations. The recommendation is 60 days.
Okay, so I have the probation violations. If there's a new charge, I don't have that here.
New charge to driver while suspended, second degree.
I don't have that file.
We can take care of some quick matters while we're.
Yeah, let's do that.
I believe Mr. Hernandez Sanchez will be on the phone.
All right, Mr. Hernandez Sanchez, are you on the line?
Yes, over here.
Okay, he's here.
This is time set for their denial probation violations. Mr. Hernandez Sanchez is prepared to admit, my understanding is the recommendation on the probation violations is 40 hours of community service.
All right. Ms. Cook, is that the recommendation from the probation department is 40 hours of community service?
No, Your Honor, the recommendation is 80 hours community service on the January 9th probation violation and 2 days jail on the second violation dated May 6th with a request to obtain a new drug and alcohol evaluation and follow recommendation.
Or you?
Yeah, with that being said, my notes may have not accurately reflected the recommendation, or I think I actually maybe crossed with Ms. Cook's recommendations, then my conversation with Mr. Rainier. With that being the case, can we push this out to the next white scene?
Yeah, we'll move this to the 29th, and that'll give you a chance to circle the wagons and figure out what we're doing. Mr. Hernandez Sanchez, we're going to continue the matter to resolve the various understandings of how this matter is going to move forward. And so we're going to set the matter to the 29th of July at 9 a.m.
Okay.
You able to be with us at that time?
Yes, I will.
All right. All right, then we'll expect to hear you on the phone on the 29th.
Ms. Cook, could you just repeat what your recommendation is again? I think I misunderstood that in the past.
Yes, the January 9th violation, we are recommending 80 hours of community service. The May 6th violation, we are recommending 2 days in jail. And for the defendant to obtain a new drug and alcohol evaluation and follow those recommendations.
Thank you.
You're welcome.
Okay.
The next matter on the docket would be David Kudikai.
All right. Is Mr. Kunikai on the line with us? David Kunikai.
I expect Mr. Kudikai on the line. In fact, he and I reviewed a statement of defendant of plea of guilty who turned into a plea. He hasn't even returned the plea of guilty signed to me to hand up today. So
Yeah. It may be that he misunderstood that if he just signed that was the end of it.
I suppose there is that possibility.
I'm just spitballing here.
I'll go with that.
Mr. Kunikai, last call. I don't hear him. I can move this to the 29th. Is that acceptable? Mr. Rainier, again, it's difficult to hear everything, but it may be, so let me repeat that Mr. Fitzsimons is under the.
Yeah, I heard, Your Honor.
Okay, great. Don't need to do that.
If we're going to move it, can we move it to August 12th, please?
That's fine. That works for me.
Yep. That's a good date for Mr. Fitzsimons as well. We'll move it to that date. Notice failure to appear today. And then hopefully we can conclude this on the 12th. And it may also be that he wasn't able to get in for some other reason. There's lots of numbers to punch in and so forth. All right, next.
You're going to have two arraignments for Ryan McGraw.
Mr. McGraw, are you on the phone?
Yes, sir.
All right, this time set for arraignment on two charges. They're both theft in the third degree. And Mr. Fitzsimons, you want to enter a plea not guilty on Mr. McGraw's behalf?
Correct, Your Honor. I waive further reading of charge instruments. I will waive reading of my state rights and enter a plea not guilty.
Right. Not guilty pleas are being entered on your behalf, Mr. McGraw, and then I suspect it makes sense to schedule this matter for that August 12th date. Does that work?
That will work for me.
Mr. Rainier?
Hello?
Who's this?
That's fine, thank you.
Okay. Who just said hello? Yeah, who is that?
This is Mr. Kunikai. I was on, I heard you guys and I heard you call my name, but I had to end the call and call back.
Okay, then hang tight for a second.
Okay, sorry.
It's all right. Okay.
Your Honor, this is City White Salmon. On Mr. McGraw's matters, if we can have a release order simply indicate that he is not to be in Harvest Market, that's all we would request at this time.
Okay. Mr. McGraw, then in connection with these charges, which are clause numbers XZ04200632 and 633, there is a pretrial condition that I'm going to impose most importantly, is that you not, you're not allowed to be in harvest market white salmon. You understand that? Mr. McGraw? I'll try again. Mr. McGraw, are you still with us? All right. So Mr. McGraw's next date in court is going to be August 12th. He's to have no criminal violations while the matter is pending. Mr. Fitzsimons is court-appointed attorney, and he's not allowed to be in harvest market white salmon. And what we may need to do is revisit this if we're not able to get him back on the phone, but I trust that you'll be able to get this information to him, Mr. Fitzsimons.
Yes, I understand.
Mr. McGraw.
I do believe, Your Honor, he's also been trespassed from that location, so
Yeah.
I think we're probably good.
I think we are, but I agree, and out of an abundance of caution, it's good to make sure that that's clear. So again, we will be back on this matter on August 12th. It may be that Mr. McGraw heard that, knew that that's all we needed to do, and he was gone.
I think that's likely.
Yeah. All right. So what we'll do is we have this PO Box 816 Bingen, and we will mail that to him, and then we'll send an email copy to you so you can provide it to him as well. Okay, Mr. Kunikai, are you still with us?
Yes, I am.
Don't take any phone calls.
I will.
All right. So, Mr. Fitzsimons.
So, Your Honor, I do have a statement of defendant on plea of guilty. Mr. Kunikai will be entering a plea of guilty to driver while suspended third. The recommendation is 90 with all 90 suspended, $1,000 fine with 750 suspended, so a $250 fine. $100 emergency response fee, $102.50 traffic penalty, conviction fee of $43, and then $135 in attorney's fees.
Okay.
So I can hand that to the court.
All right.
I reviewed this with Mr. Kunikai yesterday, emailed it to him, he signed electronically, and emailed it back to him.
All right, Mr. Kunikai, I've been handed a statement of defendant on plea of guilty, and this is a document where you intend to change your plea of guilty in this matter, and or change your plea to guilty, change your plea from not guilty to guilty in this matter, and then proceed to sentencing. If you do that, you give up certain valuable rights. Are you willing to give up those rights?
Yeah.
Okay, and by that I mean you're giving up the right to a trial, to hear and question witnesses, presumption of innocence. Those are the rights I'm talking about. You willing to give up those rights?
Yeah, I mean, everything that was talked to me yesterday, I'm doing the clear with no jail time or anything, and I just got to pay my fees and whatever else that you had to
Right.
say, so, yes.
Yeah, so the way this works, and I'm sure your lawyer told you that I frequently will follow a recommendation in these situations, but I'm not obligated to follow that recommendation. So if you plead guilty, you understand that you may be sentenced to the full 90 days in jail. Do you understand that?
No, I did not understand that.
Okay, it's a remote possibility, but it is a possibility. In other words, this is just an agreement between your attorney and the city's attorney about how I'm to handle this matter. I'm not obligated to follow their recommendation. You understand that?
Yes, I understand that.
Okay, good. You also understand if you're not a U.S. citizen, there may be adverse immigration or naturalization consequences from a plea of guilty. Do you understand that?
Yes.
Paragraph 11 of the document says, on or about February 28th, 2020, the city of White Salmon, County of Klickitat, State of Washington, I was operating a motor vehicle. My driver's license was suspended, but I was eligible to reinstate. Is that your statement, or do you adopt that statement for purposes of this proceeding?
Yes, no, yes, the statement, yes.
Okay, yes to the statement. So then with regard to the charge of driving while suspended in the third degree, what is your plea to that charge?
Guilty.
All right, I'll make a finding that plea is being made knowingly, intelligently, voluntarily. The defendant understands the charge and the consequences of the plea, and there's a factual basis for the plea, and the defendant is guilty as charged. And then Mr. Rainier, recommendation 9090, $1,750, $100 emergency response fee, $102 traffic penalty charge, $43 conviction fee, and $135 in court-appointed attorney's fees. Anything to add to that recommendation?
There's nothing aggravating or mitigating about this. He simply needs to have a license to drive. Thank you.
All right. Mr. Fitzsimons, anything to add?
Your Honor, he's got some fines he has to pay. He's actually got quite a bit to pay before he gets his license back. He's attempting to take steps towards that. I think this is a reasonable resolution of circumstances.
All right, Mr. Kunikai, this is your opportunity to say anything that you want to say with regard to this matter. Is there something that you want to say?
I'm gonna get my stuff together and situated and not do what I'm not supposed to do, and that's it.
All right, most important to that is not get behind the wheel until you have a driver's license. You understand that?
Yes, I do, Your Honor.
Because every time you do that and you get caught, it adds to the bill and makes it harder for you to eventually get your license. So until you get a license and insurance, you may not operate a motor vehicle. Do you understand that?
Yes, I do.
Okay. All right. I'm going to adopt the recommendation that's been presented by the parties, 90 days in jail with all of those suspended. So no time to serve in jail, $1,000 fine with $750 suspended, leaving a payment amount of $250 from you, Mr. Kunikai. In addition, an emergency response fee of $100, a traffic penalty charge of $102, a conviction fee of $43, and court-appointed attorney's fees of $135.
All right, but no jail time?
And no jail time. So let me total that up for you.
Okay, thank you so much.
So the total is $630.
Okay.
Let me make sure I did that right.
Do I have to do it all at once, or can I do a payment plan?
I'll allow you to make payments to the court provided that you're able to maintain regular payments. And
I will. I'm going to try. I'm going to do my best. So yes.
all right. So I need you to make monthly payments. Are you currently working?
No, I am not. And then that's another thing. Our tribe is, due to the COVID, our tribe's going to be stopping our per capita. So after September, I will be no longer receiving any kind of money coming in or anything like that. But I am looking for jobs or whatever that I can or whatever. But yes, I will try my best.
All right. So you need to make $25 a month payments to the court. I'll have your first payment due on September 1st. And the first of each month thereafter, we're going to send you a time payment card for you to sign and then return to us. We're going to put that to you at P.O. Box 951 in Bingen.
Yeah.
And then you sign the time payment card, and then you make those payments to us, $25 a month, starting September 1st.
Okay.
Now, if you're not going to be able to make a payment any month going forward, call me and I'll work with you. And our numbers on that document will send to you in the mail. If I don't hear from you and I don't receive a payment, Mr. Kunikai, then I'm just going to send it to a collection company And that's going to make it a lot worse and harder for you to get out from under. So please stay in touch with me if you're having trouble making the payment.
Yes, Your Honor.
All right.
Thank you.
Okay, I think that's it on this matter.
All right.
Thank you. You may hang up, Mr. Kunikai. Thank you for being with us.
All right. You have a great day, Your Honor. Bye.
All right, bye-bye. Perry Logan?
Yes.
Is Perry Logan on the phone?
Logan Perry.
Oh, sorry. Logan Perry.
You know, there's a chance that Mr. Perry will not be on the phone. He did have work today. He signed a stipulated order of continuance yesterday.
Okay,
With the understanding that was resolving these matters. So I do have the state of proceedings that Mr. Rainier has provided to me. Mr. Perry has signed it, and I can hand that up to the court.
all right, thank you. Mr. Rainier, anything that you want to add to this?
I'm satisfied because Mr. Fitzsimons and I have talked about this case for a long time, that he has adequately explained this to Mr. Perry. I understand also that perhaps Mr. Perry is out of our area. And if the court is satisfied with that, the city is insofar as getting this SOC signed today, which is very limited insofar as far as its requirements.
Okay, it appears to be, and I'll sign off on this. I think the most important thing is that he's no longer in contact with Ms. DeArmond, and that should, I think prior to this, he had a very limited, if any, criminal record. So hopefully that'll take care of Mr. Logan's matters. All right. I signed off on that stipulated order of continuance, and then with my signature, what we'll do is provide a copy of that to you, Mr. Fitzsimons, and you can pass it on to your client.
Sounds great.
Then I have
Mr. Sparks.
Mr. Sparks, yes.
Mr. Sparks I got notification from his mother as of last Thursday. He was transferred to treatment in Spokane. It's an inpatient treatment program. They're going to notify me when he gets out of inpatient treatment. That was really what the plan was to get him into the inpatient, keep him out of jail long enough for him to get inpatient.
All right.
I think we just need to continue that.
Mr. Rainier, should we put this out to October?
Based upon the information I have from probation, it looks like they were requesting a set over for 30 days. So whatever works, Your Honor, September or October.
All right, Ms. Cook, do you have any information on Mr. Sparks' treatment plans?
I do not, Your Honor. We've only yet received confirmation from his mother who drove him up there. We have not received documentation from the agency on how long he plans to be there. My best guess is a minimum of 30 days. Most agencies right now are not going longer than 30 days that I'm aware of. However, some are can go up to 3 months.
All right, let's assume he's going to at least get 30 days in, and let's set this then for the end of August. August 26th. And then we'll see what that brings. If he's still in treatment, then we can deal with that. Is Corelli Sanchez on the line?
Yes, I am.
All right, thank you, Ms. Sanchez. Actually, let me back up on Mr. Sparks. Ms. Cook, it looks like there is 3 probation violations, and then another one was filed on June 30th. So there's 4 probation violations. And so I'll point you on that one and enter a denial on your client's behalf. Is that acceptable, Mr. Fitzsimons? Okay. All right, so there's 4 probation violations in Mr. Sparks' matter, and we'll take that up again on August 26th. All right, Ms. Sanchez. No valid operator's license without identification. And we're working, and by we, I mean you are working on getting your license, and how's that going for you?
Well, I just paid my ticket.
Good?
I just paid it, so I'm gonna pay the other half on Tuesday.
All right.
So I'll have that bill taken care of. And then I'm gonna call, I forget his name, but the license person, Stevenson, so I can go take my test.
All right, Mr. Rainier, what's the city's position?
There appears to be progress, which is good. I'm fine with moving the matter over if the court wishes to allow her to follow through on the second payment and perhaps get her license. I'm fine moving it out further than August if that's what the court wishes.
Ms. Sanchez, make a promise to me that you can keep. When are you going to get this license?
Well, as soon as I take the test and I can get on the driver's test, I think I'll be fine. It was just the ticket in the way because I couldn't take the actual driving test without getting this matter taken care of.
But are you still studying for the test? Because you need to pass these tests, right?
Yes, I am studying.
Okay.
If you give me
There we go. We're back on. Back on YouTube. Our YouTube channel get a lot of traffic at it. A lot of traffic.
A lot of likes.
For a lot of likes. We're influencers. Do I have the jail on now? Mr. Beeks, are you there?
Yes, sir.
All right, this is James, and it appears that there was a first appearance on this matter, and so now is just the time set for arraignment on the charge of driving while license suspended in the second degree. It's cause number XC0531173.
Your Honor, waive reading of the charging instrument, waive further reading of advice and rights, enter a plea of not guilty at this time to preserve his rights.
Okay. Plea of not guilty is being entered on your behalf, Mr. Beeks. Your attorney is here in court with us in White Salmon, and he's entered a plea of not guilty on your behalf. And let me get some information from you that we may not have gotten before. Do you have a mailing address?
I do. It's the same in Dallasport.
Okay, I have P.O. Box 563, Dallasport.
Yes, sir.
Okay. How often do you check that box?
My goddaughter, she checks it, I think every day or every other day or something like that, sir.
Okay. All right, well, we're going to send you notifications about future court dates in this matter at that box. So if you're out of custody, you want to make sure that you're checking that box with some regularity because you don't want to miss a court date.
Yes, sir.
All right, then in addition to this, we have 3 probation violations, and I've appointed Mr. Fitzsimons on all of these. I think I have denials on the first 2 probation violations, or maybe not. The first one was back on February 6th, which was testing positive for amphetamine and methamphetamine on or about January 29th, 2020. And that matter, Mr. Fitzsimons, you've been appointed on, and that was denied on the 12th of February. The next one is from May 4th, and the allegation is failing to provide a valid address. And I'll appoint you, Mr. Fitzsimons, to that matter if I haven't already done so, and enter a denial on your client's behalf.
Yes, please, Your Honor.
Okay, that's done today, and that's 2. Then 3, which was filed July 7th, is being charged in the current case of driving while suspended in the second degree. And that was filed again on the 7th. I'm going to appoint you on that and enter a plea of, or deny that probation at this time. So now I think we're caught up, and we have the new matter set for arraignment, or we've just done that arraignment now. Where do we go from here? Should we?
Your Honor, the situation we're in procedurally is that he's just been arraigned on this driving while suspended in the second degree. I think that ultimately he'll be prepared to admit on these probation violations. But I'd like to wrap up that driving while suspended second degree within that admission at that point by entering a plea at that time. The recommendation right now is 60 days. Mr. Beeks is aware of that. So my request is, can we put this on? He served 15 already as of today. Can we put this on sometime within the next 45 days so we can wrap everything up? I talked to Mr. Rainier about things running concurrent as it relates to the driving while suspended and potentially to consider all these matters at one time.
We could, how about the 26th of August?
That should work.
So as I see that,
He'll be running right up, I mean, if he's getting good time, they'll be running right up to when he would probably be released on it, so can't we do that earlier?
yeah, I was just gonna do that. So August 29th is 45 days from today. So that would be, like you say, 3 days ahead of that. He should get 1 day for every 7 thereabouts. So we could do it on the 12th, and then it could be perspective in terms of wrapping it up, and then he'd have a date certain to get out
Sure.
based on that
I think
sentence.
the 12th would be a better day.
Okay, does that work for you, Mr. Rainier, August 12th?
It does. I'm waiting on discovery.
Okay, and then Mr. Beeks, we're gonna set your matter over to August 12th, which will be the next date for you to be seen on this matter. In the meantime, it appears that the warrant amount was made the bail in this matter, and so you're aware that there's cash bail required. So if you are, for some, Mr. Beeks, if you do bail out on this matter, you need to make sure that you arrange your schedule to be present in court on August 12th.
Yes, sir.
And if you're still in custody, then we'll make arrangements to have you appear. We might actually do that via video. We just thought it'd be a little bit quicker today to do it over the phone.
Thank you.
All right, thank you, Mr. Beeks. Thank you from the jail as well. I think that's it.
Thank you.
All right, thank you, Mr. Rainier.
Have a good day.
Thanks.
Okay, off the record.
All right, we're gonna hang up now. Thank you.
See ya.
Yep, see you. Thank you, Mr. Fitzsimons.